Hello and welcome to the Kenneth Verkaman Law Office Legal Podcast, the NJ Laws Tube. In this edition, we look at recent cases, and in particular, the Appellate Division case of State versus Binkiewicz. Now, the court rules were amended to require that post-conviction motions to vacate guilty pleas be heard within 5 years. Can the 5 years be waived? Yes, State versus Bringhurst said that. What if there's no transcript and it took place many years ago? Can a judge hear a PCR motion if it's not the original court? In an unpublished appellate division case, the appellate division said yes, State versus Binkiewicz, and that was where a 30-year-old uncounseled DWI conviction could not be used to enhance the jail. The court held that where the defendant's first conviction for a DWI occurred more than 30 years ago, his testimony and certification that he did not know that he was entitled to counsel, and was not asked if he wanted adjournment to obtain counsel, is sufficient under State v. Laurick to establish that the conviction was uncounseled. Having found that the conviction was uncounseled, and since subsequent convictions exceeded the 10-year time span for looking at enhanced penalties, the judge correctly applied the step-down provision and sentenced the defendant as a second offender with respect to incarceration, but as a third offender with respect to the administrative penalties after he pled guilty to his third DWI. So he lost his license for 10 years, but he did not need to go to jail for the mandatory 180 days. And that was State v. Binkiewicz by the Appellate Division, docket number A5613-06T4. For additional information, call the Law Office of Kenneth Verkaman, 732-572-0500, on the web at njlaws.com, that's njlaws.com, and benotguilty.com, that's benotguilty.com. We're at 2053 Woodbridge Avenue, Edison, New Jersey. Thank you and good luck.